This is the first video in a series of 4 videos that are focused on how rights are protected in Australia. As you'll see from these videos, there are 4 ways in which rights are protected in Australia. First, through statute. Second, through the common law. Third, under the Australian Constitution. And fourth, through international declarations and treaties. In this video, we are looking at how rights are protected in Australia by statute. There are 2 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause function so that you can pause this video when you need time to take notes. And also make sure that you use the rewind function so that you can rewind this video if you have missed any information or if you need to go back over any of the information covered in this video. Once you have finished watching and taking notes on this video, please make sure that you read sections 15.1 and 15.2 of the textbook and supplement your notes with any information from that reading that you find useful. Here is the learning intention for this video. Make sure you write this in your Cornell notes. Your learning intention for this video is to evaluate the ways in which rights are protected in Australia through statute law and the Victorian Charter of Human Rights and Responsibilities. Pause this video and take a minute to write down as many rights as you can think of that we enjoy in Australia. Well, here are some examples of rights that you might have written down. The presumption of innocence, right to work, freedom of speech, freedom from slavery, right to fair pay, freedom from discrimination, protection from inhumane punishment, right to a fair trial, freedom of religion, freedom of movement, freedom of assembly, freedom from arbitrary detention, right to safe working conditions, right to education, right not to have property confiscated without compensation, right to access the courts, right to life, right to food and water, right to vote, right to shelter, freedom of movement. So there are a lot of rights that we enjoy as Australians. Now, some of these rights are protected in Australia by statute, under the common law, under the Australian Constitution, or through international declarations and treaties. However, in many cases, these rights are not rights that are written down in any legally enforceable way, such as in a statute or a court decision. Instead, we largely depend on our democratic system of government to ensure that our rights are protected. Put another way, if a government were to try to remove any of these rights, then what we would do is vote that government out in the next election. And that's the reason that Australian governments tend to respect these rights. You'll recall that at the outset I said there were 4 ways in which rights are protected in Australia. In this slide I give you an overview of each of these 4 ways, which will be discussed in more detail in this video and the next 3 videos. The first way in which rights are protected in Australia is through statute law. There are statutes that have been passed by the Commonwealth and Victorian parliaments that protect many of the rights we enjoy today. For example, there is legislation that prohibits people being discriminated against on the basis of gender, sexual orientation, religious beliefs and race. Put another way, these statutes give us rights not to be discriminated against on the basis of gender, sexual orientation, religious beliefs and race. Also, in Victoria, we have the Victorian Charter of Human Rights and Responsibilities, which sets out some of the rights that people in Victoria enjoy. The second way in which rights are protected in Australia is under the common law. The common law is law made by judges when they are deciding cases. So, for example, the right to silence and the right to a fair trial are rights that have been developed by judges through making decisions in cases that they have heard. The third way in which rights are protected in Australia is under the Australian Constitution. The Australian Constitution protects some rights by restricting the lawmaking powers of Parliament. For example, the Australian Constitution prohibits the Commonwealth Parliament from making laws that restrict freedom of religion. The fourth and final way in which rights are protected in Australia is through international declarations and treaties. The Commonwealth Government has signed a number of international declarations and treaties. An example is the Universal Declaration of Human Rights. These instruments, that is, declarations and treaties, impose obligations on Australia to protect a range of rights. However, importantly, these rights can't be enjoyed or enforced by the Australian people unless the Commonwealth Parliament has first passed legislation that gives these rights to the Australian people. The focus of this video is on rights that are protected by statutes. In fact, most of the rights that we have in Australia and that are actually written down in a legally enforceable way are rights that are included in statutes or laws made by Parliament. While it's good that many of our rights are included in statutes, this is also a disadvantage in the sense that Parliament, being supreme, can amend these statutes to change or remove these rights at any time. In the table, I've set out some examples of rights that are protected by statutes. In particular, I draw your attention to the right to freedom from discrimination. This right is found in a range of different statutes, including the Victorian Equal Opportunity Act and the Commonwealth Racial Discrimination, Sex Discrimination, Disability Discrimination, and Age Discrimination Acts. These acts all prohibit a person from being discriminated against on the basis of certain characteristics, such as their race, their gender, whether they have a disability, and their age. Putting it another way, these acts give people rights not to be discriminated against on the basis of characteristics such as their race, gender, the existence of a disability, or their age. In Victoria, we have a very important statute or act which sets out a number of human rights for the people of Victoria. This statute is called the Victorian Charter of Human Rights and Responsibilities. The rights which the Charter contains are largely modelled on the rights contained in the International Covenant on Civil and Political Rights, which we look at briefly in the fourth video. These rights include the right to be protected by the law, the right not to be tortured, the right not to be enslaved, the right to freedom of religion, and the right to freedom of speech. Very important rights indeed. However, these rights are not like the rights that are included in other statutes. Think back to the anti-discrimination legislation that we've just looked at. This legislation gives people the right not to be discriminated against on the basis of certain characteristics such as their gender. So, for example, if an employer were to discriminate against an employee on the basis that the employee is female, then that employee could take the employer to court and obtain an order from the court that prohibited the employer from discriminating against the employee simply because she is female. Put another way, the rights in the anti-discrimination legislation are directly enforceable. That is, an individual whose rights under that legislation have been breached or infringed can go to court and take action to enforce their rights through the court. However, in the case of the rights set out in the Victorian Charter of Human Rights and Responsibilities, they are, subject to one exception, not rights that can be directly enforced by individuals. That is, if those rights are breached, generally speaking, an individual cannot go to court and obtain an order requiring the person who breaches those rights to instead observe or comply with those rights. What then does the Charter do? Well, the first thing that the Charter does is it requires that each bill which is introduced into the Victorian Parliament must be accompanied by a statement of compatibility. A statement of compatibility is a document that sets out the extent to which the bill is consistent with the rights set out in the Victorian Charter of Human Rights and Responsibilities. In particular, that statement must identify any respects in which the bill is inconsistent with, that is, breaches, the rights which are set out in the Victorian Charter. The importance of the Statement of Compatibility is that every Member of Parliament has that Statement of Compatibility before them when they are deciding whether to vote for the bill. And what this means is that the Victorian Parliament is then in a position where it can decide whether or not to pass a bill where that bill contains provisions that are incompatible or inconsistent with the rights protected by the Charter. The Victorian Parliament can still vote to pass a bill which includes provisions that are incompatible with the rights set out in the Charter. The Charter doesn't prevent that occurring. What the Charter ensures is that the Members of Parliament are aware that they are passing a bill which contains provisions that are incompatible with the rights protected by the Charter. Obviously, if the majority of the Members of Parliament don't want to pass a bill that is inconsistent with the Charter, then they can either vote to reject the bill or vote to amend that bill to remove the offending provision. The second thing which the Charter does is that it requires the courts to interpret Victorian acts as far as possible in a way that is compatible, that is consistent, with the rights protected by the Charter. You'll remember that one of the important functions of a court when they're interpreting statutes is to give meaning to the words in the statute where those words are ambiguous. What the Charter provides is that where a word in a statute is ambiguous and where one interpretation is consistent with the rights set out in the Victorian Charter of Human Rights and Responsibilities, but another interpretation is inconsistent with those rights in the sense that that interpretation would mean that the right is breached, then the court is instead to adopt the interpretation which is consistent with the rights protected by the Charter. Now, you'll recall that I said there was one exception where the rights set out in the Victorian Charter of Human Rights and Responsibilities can be directly enforced by an individual whose rights have been breached, just as in the case of other legislation such as anti-discrimination legislation. This is the case with the Victorian government agencies, because what happens here is the Charter provides that Victorian government agencies must act in a way that is compatible, that is consistent with the rights that are protected by the Charter. And if they do not do that, then the person whose rights have been infringed or breached can go to court, that is, can obtain a court order requiring the Victorian government agency to act in a way that is consistent with the Charter. In this regard, I'd like you to read the case study on page 489 of your textbooks regarding the Barwon prison. And here you can see this is a case where a court ordered the prison authorities to change their practices concerning the detention of children in prison because the way those children were being treated was inconsistent with their rights under the Victorian Charter of Human Rights and Responsibilities. The tables on this slide and the next slide contain examples of rights that are set out in the Victorian Charter of Human Rights and Responsibilities. Many of these rights will be familiar to you from work that we've already done in legal studies. Now, you don't need to remember all of these examples, but I would like you to remember at least 2 examples of rights that are set out in the Victorian Charter. I'll take you through these rights in a bit of detail now. The first example we have is the example of the right to equality before the law. That is, every person is equal before the law and is entitled to the equal protection of the law without discrimination. This is fairly obviously a fundamental right, and it takes us back to the principles of justice that we looked at the beginning of Year 11. One of those principles is the right to equality. What this means is that it doesn't matter whether you're the Prime Minister, an unemployed person, male, female, old, young, a doctor, a plumber, everyone is entitled to be treated equally by the law. The second right is the right to freedom. That is, a person must not be subjected to arbitrary arrest or detention. Again, a pretty fundamental right. What this means is that the police can't arrest you unless they have reasonable grounds for suspecting that you have committed an offence. You can't simply be taken off the street and thrown into a jail cell. The third right is the right to a fair hearing. This is one that we look at in some detail in Year 12, so it might be a very good example to remember for these purposes. What this right provides is that a person charged with a criminal offence or who is a party to a civil proceeding has the right to have that charge or proceeding decided by a competent, independent and impartial court or tribunal after a fair and public hearing. So this is a right which underlies our criminal and civil justice system, in the sense that ultimately we all have the right to have our case decided by an independent and impartial court or tribunal after a fair and public hearing. The next example is the right not to be tried or punished more than once. That is, a person must not be tried or punished more than once for an offence in respect of which that person has already been finally convicted or acquitted in accordance with the law. You can see that this right incorporates the no double jeopardy principle, which is the principle that a person must not be tried for an offence where that person has already been acquitted of that offence. That is, unless fresh and compelling evidence comes to light, or unless that person has committed perjury. But the general principle is that if a person has been acquitted of an offence, then they cannot be tried for that same offence again. Again, a very important right because it effectively stops police harassment. In other words, the police tried to get you convicted the first time, they failed because you were acquitted, then they can't simply just bring you back to court in the next month to have another go at you. The fifth set of rights are the rights of people who have been charged with a criminal offence. Now, there are a number of these rights. The two which are most important for Year 12 are firstly that an accused child has the right to be brought to trial as quickly as possible, and secondly that an adult who's been charged with a criminal offence is entitled to be tried without unreasonable delay. This is important because where a person has been charged with a criminal offence, particularly where they are a child, then the fact that that criminal offence is hanging over their heads is a very stressful thing. We know, for example, that if someone has been charged with a criminal offence, there is a tendency amongst some people in society to regard that person as guilty, even though they haven't yet had their trial. So the principle behind these two rights is that once someone has been charged, their trial must occur as quickly as possible if you're a child, and without unreasonable delay if you're an adult. The reason for the unreasonable delay qualification for adults is that some cases are very complex. So if you think of Jimmy Gargasoulis, who has been charged with murdering people by driving his car down the middle of Burke Street, the Burke Street Mall rather, at the beginning of 2017, there were hundreds of witnesses that the police had to interview. There were medical reports that had to be obtained about Jimmy Gargasoulis' drug use and his mental condition. And all of that means that there was going to be a long time required to prepare for the trial. You might contrast that with the case of someone who has been charged with breaking into or holding up a milk bar, where there's only one witness. In that case, of course, the trial can be brought on more quickly because the amount of evidence that the police need to collect is correspondingly smaller. Other rights that a person who's been charged with a criminal offence have is that they have the right to be presumed innocent until proved guilty according to the law. Again, a very, very fundamental right. This underpins our whole criminal justice system, the fact that an accused person never has to prove that they're innocent. The burden of proof is on the prosecution, and it is for the prosecution to prove beyond reasonable doubt that the accused has committed that offence before the accused can be found guilty of that offence. We also see here that a person who is charged with a criminal offence has the right to receive the assistance of an interpreter if he or she can't understand or speak English. Again, a very important right because, of course, our court proceedings are all conducted in English. And there is also the right of a person who's been charged with a criminal offence to not be compelled to testify against himself or to confess their guilt. This is a fancy way of talking about the right to silence. That is, again, consistently with the presumption of innocence, an accused cannot be forced to give evidence. They are entitled to sit back and say nothing and require the prosecution to prove beyond reasonable doubt that the accused has committed the offence before the accused can be convicted. The accused doesn't have to give any evidence in court, and they certainly don't have to answer police questions when they've been arrested, except, of course, to give their name and their address. The final example that I've set out here as a right which is contained in the Victorian Charter of Human Rights and Responsibilities is the right to appeal. Under this right, any person who is convicted of a criminal offence has the right to have their conviction and any sentence imposed on them reviewed by a higher court. This takes us back to the work that we have done on the Victorian criminal court hierarchy, and you'll remember there that we looked at the appellate jurisdiction that is exercised by courts in that criminal hierarchy, the principle being that a person who is dissatisfied with their conviction or with the sentence that's been imposed can appeal to a higher court to have that conviction or sentence reviewed. Now I'd like you to recall our learning intention. That learning intention is that you should be able to evaluate the ways in which rights are protected in Australia by statute law and the Victorian Charter of Human Rights and Responsibilities. Now there are two parts to an evaluation. The first part involves you weighing up the strengths and weaknesses of the thing that is being evaluated. So in this case, you need to be able to weigh up the strengths of statutes as a way of protecting rights against the weaknesses of statutes as a way of protecting rights. This is exactly what you've done when you've been answering discussion questions. The second part of an evaluation is that you need to give an opinion. So in this case, you would need to express an opinion as to the effectiveness of statutes as a way of protecting rights in Australia. In class, I will model for you how to write an evaluation. For now, though, we will concentrate on the first requirement of an evaluation. That is, the requirement to weigh up the strengths and weaknesses of the thing that is being evaluated. I find that a good way of preparing to answer a question of this kind is to draw up a table that sets out the two sides. So on the left-hand side, I've set out the strengths of statute law in protecting rights, and on the right-hand side, I've set out the weaknesses of statute law in protecting rights. But importantly, what I've also tried to do is to match each strength as far as possible with a related weakness. And that'll help me when I'm weighing up the strengths and weaknesses, because I'll be then comparing apples with apples rather than apples with oranges. And when I'm doing this weighing up, I will be using words of difference. So I'll be using words such as on the other hand, in contrast, however, whereas, and while. Let me then take you through this table. The first strength that I've identified of statute law in protecting rights is that Parliament is able to amend statutes to include additional rights. So if Parliament determines that there's another right that should be protected, it simply passes a law to include that right in a statute. However, just as Parliament is able to amend statutes to include additional rights, Parliament, being supreme, can also amend statutes to change or remove existing rights. So that is a weakness of statute law in protecting rights. The second strength of statute law in protecting rights is that the statutes set out clearly the rights that are being protected. That is, you can read what those rights are in the statute itself. However, just as statutes set out what the rights are, they can also limit those rights. For example, the Commonwealth Electoral Act gives people the right to vote. It expressly sets out that right. However, the Commonwealth Electoral Act also imposes some limitations on that right to vote. For example, the Commonwealth Electoral Act says that people who are serving a term of imprisonment of more than 3 years are not allowed to vote in federal elections. The third strength of statute law in protecting rights is that where a right is set out in a statute, it can generally be enforced by a person whose rights have been breached. And that enforcement occurs when the person goes to court for an order that the person who's breaching the rights stops breaching those rights. However, on the other side, we know that not all statutory rights are enforceable. We've just looked at the Victorian Charter of Human Rights and Responsibilities, which sets out a large list of rights. But that doesn't stop the Victorian Parliament, for example, from passing a law that infringes or breaches those rights. And if the Victorian Parliament does pass a law that infringes or breaches those rights, then there's nothing that an individual can do. They can't go to court and ask the court to rule that legislation to be invalid, because the legislation is not invalid. There's no way that you can enforce your right in that circumstance. All right, well, that brings us to the end of this first video. Remember that your learning intention, or what you should be able to do now, is to evaluate the ways in which rights are protected in Australia by statute law and the Victorian Charter of Human Rights and Responsibilities. Please remember now to read sections 15.1 and 15.2 of the textbook and supplement your notes with any information from that reading that you find to be useful. Thank you very much for your attention.